Hey everybody, welcome to another American Courts video. Today we take you to Judge Simpson, a judge in Ann Arbor, Michigan. Here is his channel. Check it out. Make sure to like and subscribe. Today we're going to show some probable cause conferences from October 10th, 2024. All right, here we go.
Assistant Public Defender Cedric really on behalf of Miss Shelby Miller.
Well. Long time no see.
Yes, Your Honor. It's a pleasure to be here.
Yeah, we'll see. All right.
Your Honor, today is a date and time set for probable cause conference in Ms. Miller's matter. We are still in negotiations with the people. Yes,
Miller, could you state your name, please? I'm sorry.
that's okay.
Shelby Miller. I go by male pronouns though, please.
Okay,
Yeah, thank
I
you.
will. I'll note that in the file.
Thank-
If I make a mistake, it's not on purpose. Okay,
Thank you.
thank you. Okay, what are we doing on this?
Your Honor, we are asking for an adjournment. I will just be asking for 2 weeks. I did have an opportunity to speak with Shelby, and we have a plan set forward, so I just need to speak with the people about it.
That objection, October 24th, 2024, and you probably don't know about a green sheet, but I'm gonna need one, please.
Sure thing.
Bond will continue. Thank you,
Thank
sir.
you.
Court does call the case, People versus Rebecca Valentine.
Epsilon for the people. Assistant Public Defender Chinaze really on behalf of Rebecca Valentine, Your Honor.
Valentine, can you state your name, please?
Yes, and I did say I want to represent myself, so I don't know where that communication was filled. Rebecca Valentine, I don't wish to have an attorney represent me.
Okay, you want to represent yourself in this matter?
Yes,
Okay, so what do you want to do today if that were the case?
what are my options?
Pardon?
What are my options?
I can't apprise you of that, ma'am. I can't give you legal advice.
Probably just adjourn it for 2 weeks and they could let me know what they want to do next.
Have you spoken to the public defender or an attorney at all, ma'am?
Yes, she was very inconvenient and not communicated with me, and I let her know I would like to represent myself. I think that you're allowed to tell me like reasonable information, and then I can make a reasonable choice about my own representation. Is that not, am I right?
Well, thank you for letting me know what my job is, but that's not how it works.
You're welcome, but I would think you should know this already.
October 24th, 2024, 9 a.m.
Sounds
I'll
good.
consider that a waiver of her time requirements. Bond continue. Thank you.
You're welcome.
Should I put anything on the record?
What'd you say?
I guess it would be fair. For the record, Your Honor, I did try and reach out to Ms. Valentine.
How'd that go?
It didn't go very well, Your Honor.
Oh, I'm just asking. I don't know. You don't have to answer me. That would be privileged. Did it go as well as my conversation just now?
You actually heard her voice. So
Oh, okay. That must be part of my charm. Court does call the case of the People versus Jerell Child.
Good morning, Your Honor. Ken House, attorney, sending in for person, the prosecuting attorney, name your riser.
Good morning, Rob J. Kilwell, Judge. I'm standing in for Sam Bernstein, who is attending his grandmother's funeral. I've had a chance to speak with
Sir,
him.
do you have any objection to that?
Yes,
You have objection to me standing in for Sam just for this hearing?
yes.
You do?
Your Honor, we just spoke. All I'm gonna do is ask for an adjournment. You want Sam here to ask for that?
No.
Can I ask?
Uh,
The judge is asking, do you have a problem with me standing in just for today, asking for the adjournment?
you can ask for the adjournment.
Okay, but that's not the question. Do you object to me handling your affair just today?
Yes.
You,
Okay, let's do it this way. I'm Mr. Bernstein has other people in his office. So I don't know if they're available. Tucker Foster. Because I'm not gonna go through this one.
okay, all I was gonna do is ask for an adjournment, then Sam will be
Yes,
back
good.
next time.
It's
Okay,
good.
but you have to tell the judge it's okay for me handling your affairs just today.
Okay.
Tell the judge
It's okay.
that I handle your affair today.
Yes.
Okay,
Judge, thank you. That being said, my instructions were to ask for a 2-week adjournment, please.
No objection, Your Honor.
probable cause conference, October 24th, 2024. 9 a.m. bond continue.
Thank you. Thank you.
So you did.
Yeah, Sam will come and see you, okay?
No, I haven't done anything.
Okay. Court calls the case. Oh, yes. Good, thank you. Court calls the case, People versus Joseph Deliz.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Deliz, who is present via Zoom, Judge.
Sir, can you unmute and state your name? Are you trying?
Are you able to ask someone, sir?
We're trying to force him, but. Miss Mahmood? Good morning. Now, sometimes while we wait, sometimes you just have family hanging around. And sometimes when you have family hanging around, they're sometimes doing things that they probably shouldn't be doing.
Already know.
Right next to you, but it's okay. She already knows?
Yeah.
Okay.
Great. Picture right here.
Not so much. No. Is he? So we can't force him? It's not, okay. Let me just pass it briefly and
Thank you, Your Honor.
see. Oh, no. I thought somebody was coming in new now. Okay. We'll call. So,
Did we approach on Deliz?
no.
I think they brought the wrong guy. Our guy is 34 years old. And I just looked at.
Might be a rough life. Maybe. I don't know. Your guy is what?
Joseph Chad Deliz, born in 1990.
Wow.
I just looked at his Otis photo.
Is this Mr. Deliz? And they said yes.
Bad lighting.
That's all I got.
What year was he born?
1990.
So he should look like him. Yeah.
He said he looks like him. Said he looks like him.
It looks like Mike. So that's probably the wrong guy. Are you sure that date of birth is?
Joseph Chad Deliz is who we're looking for.
Are we going to be able to check? Are you?
Check what GIS says.
Well, that's what Mike did. March 27th, 1990. Okay, well, it might be him. Why don't we ask Wayne County what this guy's date of birth is? Mr. Deliz, can you hear me? Shake your head if you can hear me. Okay, were you born in 1990? Shake your head if it's a no. Yeah, I didn't think so. All right, so that's probably the wrong guy. Huh? Officer, thank you. We're looking for a Mr. Deliz that was born in 1990. I don't think this is him.
Okay.
Okay.
And it's
so-
John Deliz, is that?
Pardon?
And is John Deliz the name?
Well, it's Joseph, I think.
Joseph? What's your
Is that who we're looking for?
So yeah, this
We're
is
looking
John.
for a Joseph Chad Deliz.
32790.
32790.
Okay, yes, you are right. It does say Joseph. So we don't have a Joseph in custody. So
You don't have him?
no.
Alrighty. Thank you. And
My
Mr.
apologies.
Deliz, thank you. Not a problem. So
Your Honor,
on the Joseph Deliz born in 1990 case, what do you want to do?
Your Honor, looking at Otis now, it has him at Parnell Correctional.
Got it.
Your Honor, I'd ask to adjourn the matter so we can find him and get him here.
October 31st.
Thank you, Judge.
Court calls the case People versus Wayne Eagleston or Eagleston.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Eagleston. That's just me. You're gonna get sentenced by Judge Fletcher and not Simpson. I'll draw rights if we talk about. Thank you, Mr. Allen.
Your name, sir?
Wayne Eggleston.
All right, I have before me a plea form that indicates the defendant is going to be pleading guilty to the charge of attempted unlawful use of a motor vehicle, 1 year offense. Upon his successful plea to that charge, count one would be dismissed. I guess that's SA is sentence agreement.
That's correct, Your Honor.
Sentence agreement to 1 year in jail, which this court cannot bind the sentencing judge to, although I understand it's your agreement, and no delayed or deferred. Again, this court is not binding the sentencing judge to that.
Thank you.
That's correct, Your Honor.
Let's have him sworn.
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Wayne Eggleston.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted unlawful use of a motor vehicle.
Correct.
All right, that's a misdemeanor punishable by up to 1 year incarceration and a $750 fine plus court costs, as well as license suspensions by the Secretary of State. You understand that?
Yes.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Correct.
All right. Still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct, sir?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
All right. Which one?
Probation.
All right. Were you on probation at the time of this offense?
No.
You sure? You don't know.
It's the same offense in a different county. Same day, same offense. Different charge.
All right. So you're on probation in another county
For this.
that happened after or for this, but the events occurred in a different county.
Yep.
Okay. Then I don't think you did.
Another different charge, different county, same case.
Same possession of the same vehicle in a different county.
Yep. Same vehicle, same accident. Yep. Different county.
All right.
Add another charge to it, yep.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced?
No,
You're doing this voluntarily
correct.
of your own free will
Yes,
because you believe that you are indeed guilty?
yes.
July 23rd, 2023, at the location of 9575 Austin Road, Bridgewater Township, Washington County, State of Michigan. What'd you do that makes you think that you're guilty?
I used one of the work trucks and got in an accident.
Did you have permission to take that truck? For that purpose?
Not to get in an accident, no.
Well, did you have permission to take the truck at all?
Depending on the circumstance, but no, let's say no. Let's go with no.
You had permission to take the truck for work purposes, correct?
Yes,
And you took the truck for non-work purposes?
correct. There
And
you
you
go.
didn't have permission, is that correct?
Correct.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes.
Whoa, not the.
Oh, he thinks it's funny that I'm, it's,
I don't think anything's funny about it, sir. I'm just telling you, you weren't answering my question.
I used the truck for non-work purposes, so I didn't have permission at the time that I took it. Correct.
I'm sad. Defense is satisfied. Thank you, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
October 29th at 9 a.m. before the rush hour.
October 29th, 2024, 9 a.m. before Judge Fresh Hour. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case.
Okay.
I'll pass.
Your Honor, thank you.
Court does call the case of People versus Eric Harris.
Special levy for the people.
Was here. Yeah, he's just a public defender on behalf of Mr. Harris, Your Honor.
That used to be back.
Hey, Chairman.
My name is Eric Jones. Eric Harris. All right, what are we doing?
Your Honor, we have two matters up. I have prepared and signed a request for screening into the 15th District Mental Health Court. Actually, I need to absolutely.
And how long is that taking, you think?
Your Honor, they meet every other Wednesday, so maybe 3 to 4 weeks.
3 weeks.
They just met, yes, well, I attended, it was yesterday.
Probable cause conference, October 31st, 2024, 9 a.m.
Your Honor, support received progress for community corrections that indicates the defendant was testing at Ann Arbor Treatment Center has had positives at that facility. I think the report was dated October 1.
I have that. He actually has a bond out. He actually has a warrant out at this point.
Yes, Your Honor, if I may address that.
Go ahead.
Your Honor, Mr. Harris, there was the testing information. He came to my office on Monday morning. We discussed the matter with, or Tuesday morning, I can't remember now. We discussed the matter with his provider at the treatment center. He informed us that Mr. Harris is prescribed methadone and it's provided for him there. He also said that he had provided a new test to Community Corrections that was dated October 9th, I believe that, or October 7th, that was clean for things that he was not prescribed for. I reached out to the agent and to see if he had the test, and he hadn't. I believe Mr. Harris would, if the court wanted to test him today, would likely come back negative. I'd ask the court to consider.
He'd come back negative today?
Yes, except for, I think for the, what is it called?
Methadone.
Methadone, sorry, Judge. But, in talking to his agent there, I guess, in certain circumstances, fentanyl can stay in your system for some time. But, I believe he's had a negative test, recently for fentanyl that, his agent, advised, that he had sent over to community corrections. This
Did you
is
see the screening results?
may approach and make sure I have the right ones. Yes, Judge, I have seen those, and I believe there's an October, a more recent test than that is negative.
And Your Honor, I do believe that people have received the same documentation. This is not a format that I am personally accustomed to receive drug results in. However, it is my understanding that it indicates the positive urinalysis on the 9th, November 10th, November 18th, November 26th, each for methamphetamine. There also could be positive tests from
Yeah.
the methadone is a separate test, which is under here as MTAB versus
Yeah.
MTAB, I believe. I believe MTAB indicates methamphetamine. My best understanding, it may or may not, but the MTAB is what I believe indicates methadone. I believe that's a different result. And then I also see, if I'm reading this correctly, positive fentanyl tests from 8/28, 9/9, 9/10,
Yes, sir.
negative on 9/18. Which is interesting, and then positive on 9/18.
Your Honor, if I might, I believe the meth portion is methadone, the MTAB, and speaking to Kenneth Hammond from the treatment facility, the meth is methadone and the MTAB is a metabolite, and the fentanyl is, well, fentanyl. That's my
Okay.
understanding from speaking to him.
But why is fentanyl showing up?
Your Honor, that Mr. Harris Jones is currently on tether. He is working to maintain sobriety. I believe his latest test, where we did, and Mr. Hammond said he sent it over to community corrections. I can call and see. I had hoped the court would have it. Was negative. He reported that to me earlier.
Right, but all that's gonna tell me is that it's periodically using. Because the one before that on the 18th is negative regarding fentanyl, but then the 26th is positive.
Can I speak, Your Honor?
If you want to.
Yeah, never mind.
Yeah.
Okay, I'm not using periodically though.
Pardon?
I'm not using periodically. That was just, never mind. Go ahead. Never mind. Go ahead. All right.
Your Honor, as I said, he is in a program. He is, I believe he is endeavoring to work his hardest at it. His latest test would be negative. I'd ask the court to consider admonishing him not to use to continue testing and to stay within the parameters of the treatment program that he's involved in currently. He has several things going for him. He does have a meeting next Tuesday on the 15th at 3:00 with community mental health. He's been going through their screening process. This is with the housing people.
Okay. I don't have a problem with any of that. But what I'm gonna do at this time, I'm gonna remand the defendant $25,000 cash surety bond on each case, which was the bench warrants that I set. And then once he is looked at by the folks at, I will reconsider that. I don't have a problem doing that, but there doesn't seem to be much of this that's kind of holding him in at this point, and that's what concerns me.
Thank you, Your Honor.
I'll set it for the 31st at 9 a.m.
Thank you. Michael Gaddy, Assistant Public Defender on behalf of Mr. Patterson, who's here to my right, Judge.
State your name. Patterson. Thank you. All right,
Yeah.
what are we doing?
Your Honor, the people have offered potentially a one to dismiss one count if we were to waive and plead to one count in this matter.
I should have taken.
Mr. Patterson has decided not to avail himself of that offer and wishes to schedule a preliminary examination.
Okay. Thank you.
Hold on, wait here.
Discovery is complete.
Yes, Judge.
People have their witnesses available the 22nd.
Just one moment, Your Honor. We'll try for that date, Your Honor. Thank you.
Preliminary examination in person, October 22nd, 2024, 9 a.m. That is before Judge Washington. Bond continued.
That's just a notice.
Court calls case Peter versus Rachel Pichette.
And good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Mr. Thiam. Mr. Thiam, can you please state your name for the record?
Moussa Thiam.
Thank you.
All right. What are we doing? Oops.
Your Honor, oh, go ahead.
Hang on a second. Okay, go ahead.
Your Honor, we submitted a request for an adjournment. We just need a 2-week adjournment on this one for resolution.
There is a bond violation. Are you aware of that, counsel?
Yes, I did receive that from the court yesterday, Your Honor.
All right. Well, he hasn't tested.
Your Honor, I did discuss that with Mr. Thiam. He woke up late and then did not have a ride to the testing center. I did have a discussion with him and explain how important it is that he needs to appear for testing no matter what, no excuses. And I explained to him what Your Honor can do if he does not get in compliance. He understands that. And Your Honor, I think that hopefully this is not an issue anymore.
Thank you, Your Honor. This was similarly an issue when we were here on September 26th. We adjourned for him to meet. That's my notes for him to get as well. The fact that he still hasn't gone is concerning.
Right.
Your Honor, he did enroll. He enrolled on the 26th of September. He left court and went directly over to community corrections. He just missed the test on October 3rd, or at least that's my understanding.
Yeah.
Well, but he was testing on the 27th. He didn't test on the 27th.
I see that, Judge. I apologize. In my eyes, I read that as the 26th. I thought that was the same date that it went in. So that's my apologies, Your Honor.
Right. So he was to test on the 27th, unable to refuse. October 3rd, he just missed.
Right. Yep.
And that was after, hold on, that was after I reissued the testing order to him.
Yes, Your Honor.
So why should I be giving him another break?
Your Honor, I think with Mr. Thiam, his age and being young and just now going through this type of situation, I just want to let Your Honor.
Front of me. He was right in front of me and I told him what he needed to do and he hasn't done it.
Correct. Your Honor, yes, I see that he has missed that test on the 27th as well as the 3rd. He did leave the court and go at least check in there. You know, he left right directly from the courthouse and walked over to community corrections, Your Honor. But again, I've given him a very stern talking to about how important it is that he be in compliance with Your Honor's orders. And I think he understands that at this point. So I'm just asking Your Honor to just give him one more opportunity to be in compliance. I hope he does, but I think he's going to.
No, that's not how this works. I mean, I issued a new order, gave him a break the first time when he didn't even go over there. He ignored the magistrate's orders and then he just ignored mine.
I understand, Judge, completely.
I will adjourn this out 2 weeks to the 24th. Well, no, I'm not going to do it that way. It's adjourned out to next week, the 17th. Defendant's bond's revoked. He needs to turn himself into the Washtenaw County Jail by 6 p.m. today.
Got it, Your Honor. I'll let him know.
If he doesn't turn himself in by 6 p.m. today, I'm going to issue a warrant with no bond.
Thank you, Judge.
Thank you.
Have a great day.
Yes, will do. Court calls the case of the people. Court calls the case people versus Brian Hagger.
Mike Jennings, public defender on behalf of Mr. Haggard, who's approaching as well, Judge.
Your name, sir?
Brian Haggard, Your Honor.
Thank you. Nope.
Maybe I could give that, we could exchange.
Exchange the two things.
Your office right now. It
All
does include positive tests for cocaine. And it is a case that I am requesting an adjournment. It came in as an OWI investigation. I wanted to charge it immediately, given this person's substantial substance abuse and violence given to the police officer, given that it's an RNO case. Since then, his blood has come back, and I am ready to move forward with an OWI third charge against him. But I'll need to authorize that and then have it resworn to, and then if we could address the bond violation as well. I'm sending this in, but summarize September 5th, benzodiazepine and THC and buprenorphine positive, November 11th missed, November 12th, those same three substances, as well as cocaine, despite not earlier. November 20th, positive for those two substances as well as cocaine.
November.
Yeah, I'm not reckoning we got there yet.
I'm sorry, I'm meaning to say September. I'm so sorry.
Thank you.
September 5th, September 11th, September 12th. I apologize.
Got it. It's okay.
September 20th, buprenorphine, cocaine, THC. September 24th, missed. September 28th, buprenorphine, THC. October 3rd, buprenorphine, THC. Sorry for that.
Yes. All right.
It's in my car.
12, cocaine positive is confirmed by Redwood toxicology. And that is.
Okay. You said cocaine was confirmed?
Your Honor, while we don't have, since there's another case coming, we don't, it doesn't make sense to hold the exam on the RNO, than to set the other one. So I wouldn't object to the adjournment. Actually, I filled out the green form, so I guess I don't. In terms of the bond violation, Your Honor, I believe there's been some tests as of late. He does, Mr. Hager does have a prescription for the buprenorphine, the Suboxone that we can provide to. They should have.
Okay, so what about the cocaine?
Your Honor, he denies that. We've certainly he sent that out to the Redwood. Had community corrections send that out to the Redwood lab for verification. I believe it did come back. I believe there has been tests since then. These tests were in September. We're now almost in double digits in October. I'd ask the court to adjourn this matter and keep the bond violation pending to allow him to demonstrate to the court that he can comply with the court's testing, not just its directives, but its mandates that he not test positive for these substances.
This time, I'm going to adjourn this out. I'm only going to adjourn it out 2 weeks. He's going to have some other type of plan in effect or some other type of thing. But at this time, I'm going to revoke the defendant's bond. Defendant's remanded to the Washtenaw County. Court calls the case People versus Phillip Zabawa.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Zabawa. Can you state your name for the record, sir?
Yes,
Can you state your name, please?
Phillip Zabawa.
Your Honor, we'd be asking to set the matter for preliminary examination.
All discovery is complete.
To my knowledge, it is.
People would have their witnesses available the 22nd.
Just one moment, please, Your Honor.
Yeah,
Your Honor, is the court received the violation?
I am.
Sorry, would the court mind if we could address that first before we set the exam date? We could potentially do the 22nd, but I'm extremely concerned. As recently as October 3rd, it was testing positive for fentanyl and opiates.
You had that?
It's my understanding that those positive tests did exist. My client has provided with us a letter from Sacred Heart. He gets scheduled for intake there at October 14th. So while it looks like he may have had a relapse, he is taking the appropriate measures for his recovery.
Yeah, may I make a statement?
You may.
I don't want you to unless you tell me what you're going to say first.
I just take it.
Mr. Allen.
And Your Honor, the concern of the people is, of course, the most recent positive test being a week ago today, but also that the defendant has never tested negative. Every single test that he's supposed to submit to community correction has either been missed or positive.
I'll just take it. No.
As my client reports, it was not his intent to be taking fentanyl. He didn't know that was in the substance that he had used. He does understand that he has
What was he intending on using?
oxy pills, Your Honor.
I
don't want you to say it because if you say it, it's an admission. If I say it, it's not.
Well, I don't know about all that. Anyway. Anything else?
Judge, only, like I said, he has the intake scheduled for the 14th, so he is taking the appropriate steps to manage that. I would ask the court to allow him to go to treatment and stay out of custody.
Still want it set for exam?
I do, Your Honor. And he does indicate to me that Bright Recovery would take him today. He just doesn't, but he has, I don't have any paperwork to that effect, but that's just what he's reporting. They wouldn't. Okay.
Your Honor, unfortunately, I'm sure the court has this on the community corrections report on the second page indicating that the defendant said that he had a tree fall on him. He wanted to get into inpatient on 10-2. It's sort of like lots of information provided community corrections about plans. And now there's another plan for the 14th. And I understand that is his hope. But the concern of the people is whether or not he's going to make it to the 14th, frankly.
Preliminary examination will be set the 22nd, 2024 at 9 a.m. That is before Judge Fresh Hour. This time defendant's bond because of the positive test and community corrections violation. His bond is hereby ordered revoked. Defendant commanded.
Somebody will see you, sir.
Court calls case People versus Harry Brennan.
And Your Honor, Joe Simon, on behalf of Mr. Brennan, state your name, Harry.
Harry Brennan, Your Honor.
Not gonna work. It's not. It's gonna be a minute. Did you notice?
Did I notice? I'm sorry.
Yeah, we've already talked.
What's her name?
Passan? Morgan Passan.
All right, go ahead. You had to have a long conversation about it.
No, actually, Your Honor, what I told her, and I'll tell the truth, is the Little Mermaid is how I know that name. She explained to me.
Oh my God. Really?
Yeah, she explained to me what the origin of the name was, and only because of the Little Mermaid did I know how to say that word. So I'll be honest, my kids watch that a lot. So. That's all.
That's beautiful, Joe.
Thank you.
Little embarrassing. All right.
Nevertheless, Ms. Masson and I have had discussions that started today about a negotiated resolution. And we're asking for a very brief adjournment of the PCC to further those discussions.
How much time you guys? You guys?
A week or two,
For the
either one.
31st work?
Yes.
31st.
Thank you.
Probable cause conference in this matter will be adjourned October 31st, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.